Welcome to the Lead-Based Paint Hazard Law DCA webinar series. My name is Kaya King. I'm the Director of Policy and External Affairs for the Department of Community Affairs. I'm joined by my fantastic colleague, Marie Daniels from the Division of Codes and Standards, and we'll both be making this presentation today. We do have a link included with information on the guidance document, inspection levels, as well as information on respective contracting firms to perform lead abatement services and remediation services. So at this time, we're going to go ahead and get started. And thank you all for your attendance today. So this webinar series is going over a very seminal law, Chapter 182, PL 2021, lead-based paint hazards in rental dwellings. So we're going to go over just some of the kind of backdrop and importance of why this law is so critical, and then also get into some technical information for you all to assist with compliance under the Act. So let's first talk about lead and its associated hazards, right? What really was the why behind such critical legislation being passed? And so lead is a naturally occurring element and heavy metal in our environment. As some of you may be aware, this was a widely used element in various industrial processes and commercial products. That included use in gasoline, paint, cosmetic, spices, and pottery. Throughout the 20th century to the present day, various health experts have been able to, find really positive determination and definitive evidence of the harmful effects on lead on human physiological and behavioral health. And so that's a well-known fact that's been understood by public health experts. And it's important to note when we talk about lead exposure, that happens when people encounter lead in their environment. So that can be through household paint or some type of commercial product. It can be through contaminated soil or other sources. And exposure for lead is determined by measuring the concentration of lead in a person's blood. So speaking a little bit more to that, when we look at these associated hazards, right, the lead exposure happens when that lead has been introduced into a human being's bloodstream by ingestion or inhalation of lead dust. Our bodies can't distinguish lead from other minerals like iron or calcium. So accordingly, lead is then deposited into our organs as well as our brain and bone marrow. The Center for Disease Control, which does establish certain thresholds for elevated blood lead levels, speaks to a number of the health impacts, particularly of concern for children. And here's some here listed. It includes this, but it is not limited to nervous system damage, kidney damage, learning disabilities like ADD, decreased intelligence, behavioral problems, speech and language problems, hearing damage, decreased muscle and bone growth, and poor muscle coordination. And again, another important caveat, children under the age of 6 and pregnant women are at the highest risk for exposure. So any lead that a pregnant woman is exposed to transfers to the fetus and is present at birth. And small children have a high rate of hand-to-mouth contact. And for those of you that have ever been around a young child, a toddler, I'm sure you're aware that children are constantly putting their hands and putting things in their mouth, right? So they can get that lead exposure by putting their hands on something that maybe has lead dust and then putting that into their mouth. Also chewing on lead-based paint chips that can peel off the wall, chewing on windowsills, door frames, or any other surfaces containing lead-based paint. And anyone who's ever been around a young child, especially one teething, knows they will put almost anything in their mouth. So that's part of why you have this higher risk of exposure for children, right? And why the lead-based paint hazards are such an issue. So let's speak a little bit to those lead-based paint hazards. And I'd be remiss if I just didn't remind folks, I know we talked about other sources of exposure. This law is purely focused on lead-based paint hazards, right? So not soil exposure, not plumbing exposure. So I just wanted to give that caveat in mind and really help for all of you to really narrow down what are the expectations and requirements for this act specifically when we're talking about lead hazards. So here we wanted to just identify some of the ways that a municipality, a contractor can identify lead-based hazards, right? So deteriorating lead-based paint, right, which we were talking about earlier. So peeling, chipping, caulking, cracking, or damaged paint, that is a hazard that would require immediate attention. It may also be a hazard when it is found on surfaces that get a lot of wear and tear. So think about your windows and windowsills in a household doors and door frames, stairs, railings, banisters, and porches. So any of those areas that really just have high traffic by those that are inhabiting that dwelling, that's the areas that really need to be a focus point for any inspection considerations. Also important to note that lead dust can form when lead-based paint is scraped, sanded, or heated, right? So dust also forms when paint surfaces bump or rub together. Lead chips and dust can reside on surfaces and objects that people touch, right? As we go back to that example of the toddler, right? Touching a surface that has that lead dust. The settled dust can re-enter the air when people vacuum, sweep, or walk through an affected area. So it's important to keep in mind, it's not simply about the paint consideration only, it could also be about the dust that can be generated from that lead-based paint. So let's talk a bit more about the actual act itself, right? What is PL 2021 Chapter 182? This is a law concerning lead-based paint hazards, right, in residential rental property. This law imposes an obligation on municipalities to perform or hire a certified lead evaluation contractor to perform inspections of certain single-family, two-family, or multiple rental dwellings for lead-based paint hazards at times specified within the law. A municipality is to permit a dwelling owner or landlord to directly hire a certified lead eval contractor for this purpose. And if a lead-based paint hazard is identified, that owner of the dwelling is to remediate the hazards, either through abatement or lead-based paint hazard control mechanisms. And we're going to go over some more details on abatement and these control mechanisms shortly. Individuals are certified as lead inspector risk assessors, lead abatement workers, and lead abatement supervisors by the New Jersey Department of Health. And this is pursuant to their regulations at New Jersey Administrative Code 8:62 under the authority of NJSA 26:2Q-1. We've included here a link that Marie has also dropped in the chat to find out information for an individual to be certified. It is important to recognize the distinction, though, that the Department of Community Affairs certifies the firms that perform lead evaluation or abatement services. And we've included a link in this presentation and also in the chat. So just keep those considerations in mind, that DOH is the ones that certify individuals and DCA certifies the firms. So speaking a little bit more to this law, what are the dwellings that are applicable under the act, right? So dwellings that are to be inspected under Chapter 182, so single family rental dwellings, two family rental dwellings, and multiple rental dwellings. And it's important to note, because I know we've seen some questions about this as well, this does also apply to rented condominiums or co-ops. Also, any owner-occupied properties where there's a unit being rented that meets the obligations under this act, that also would need to be inspected. And I know we've seen also some questions about, folks where it was they originally purchased a pre-1978 home, but then want to rent it out in the future. If that dwelling is ever rented, this law does apply. So it's important to keep that in mind. Also equally important is going over the dwellings that would be exempt from inspection, right? What are the dwellings that municipalities or owners would not have to be found to abide by under this act? So dwellings that were constructed during or after 1978, those are exempt under this act. Dwellings that have been certified to be free of lead-based paint in accordance with the regulations promulgated by the department, NJAC 5:17-3.6b. Dwellings with a valid lead safe certification pursuant to this law, which is valid for 2 years. And I'll take a quick pause here because I know there may be a bit of confusion or nuance about lead-free versus lead-safe. So a lead-free certification will always exempt a rental unit from inspections under this law. So if you have a dwelling that undergoes renovation and is in the process of being certified as being lead-free, it will no longer be required to comply with this law. That is distinctive from the valid lead-safe certification. And my colleague, Ms. Daniels, will go over that briefly so that that nuance is understood. Lastly, on this slide, single family and two family seasonal rental dwellings, which are rented for less than 6 months duration each year by tenants that do not have consecutive lease renewals. So this exemption does not apply to seasonal multiple dwellings. So keep note of that. Couple other considerations we wanted to note with dwellings that are exempt. So multiple rental dwellings that have been registered with DCA for at least 10 years and have no outstanding lead violations from the most recent cyclical inspection performed on the multiple dwelling under the Hotel and Multiple Dwellings Law, that's exempt. So all multiple dwellings that were constructed prior to 1978 and registered with the department for at least 10 years that have that certificate of inspection issued by DCA, Bureau of Housing Inspection, they're exempt. It's important to note a certificate of inspection means that there are no outstanding violations, which is why these types of dwellings would be exempted under the Act. A multiple dwelling that has been registered with the department for at least 10 years with an open inspection that has no violations for paint is also exempt from this requirement. And we just want to highlight here, when we talk about open inspections, that means that these are inspections that are ongoing, right, to remediate violations during a cyclical inspection. But it's important to note during that cyclical inspection, the department cites for paint violations rather than lead violations. So in order to ensure a periodic lead-based paint inspection occurs where needed, any open paint violation in a dwelling unit will necessitate compliance with this law. So right now, I'm going to turn this over to my fantastic colleague, Marie Daniels, and she's going to speak a bit further to the periodic inspection requirements and some of the various components and obligations under the Act. Marie, the floor is yours, and thank you.
Thank you, Kaya, and good afternoon, everyone. So we're going to start with the responsibility for performing the periodic inspection. And this really breaks down in two main ways with this third option. But the main way, the primary responsibility, first, we have the municipal inspector. So the way the law is structured, in a municipality that maintains a permanent local agency for the purpose of conducting inspections and enforcing laws, ordinances, and any regulations in buildings and structures, that agency is responsible for performing the required inspection. One thing to note here is that that can shake out a little bit differently depending on the structure of the town. Any agency that has the authority to enter into buildings to enforce any regulations and ordinances can have individuals perform these inspections. And we'll get into the necessary training for those inspectors later. So this could shake out across multiple agencies. Next, you have a lead evaluation contractor. So this is for a municipality that does not maintain any permanent local agency for the purpose of conducting those inspections in buildings. Those towns will have to hire a lead evaluation contractor to perform the inspections. And then lastly, where I said you have that option, there's always the landlord or owner choice. So regardless of whether the municipality has a permanent local agency or not, if the landlord or owner so chooses, the municipality must allow the dwelling owner or the landlord to hire a certified lead evaluation contractor to perform the inspection on their dwellings. One thing I'd like to note here is the emphasis on landlord or owner choice. So the law does not allow for any municipality to require landlords to do this on their own. However, landlords can choose to do that. And moving from there, of course, we have the timeline for this periodic inspection because it is an ongoing procedure that's established through this law. So the law stated that all rental dwelling units that are required to be inspected pursuant to this law have to be inspected within 2 years of the effective date, which was on July 22nd, 2022, or upon the first tenant turnover, whichever is earlier. So of course, this means if you're thinking of any long-term tenancies you may have in the town, that the first inspection must take place no later than July 22nd, 2024, or again, the first tenant turnover leading up to that time. So that's something to keep in mind as far as where the periodic, that first inspection takes place by July 22nd, 2024. And of course, it's also equally important to know how this inspection is going to take place. And the law again splits this into two different pieces. If there are dwellings located in a municipality in which less than 3% of children tested 6 years of age or younger have a blood lead level that's greater than or equal to 5 micrograms per deciliter, then that inspection may be carried out through a visual inspection. Now, of course, these municipalities can elect to undertake dust wipe sampling. However, if you're below that 3% threshold for an elevated blood lead level, you can perform a visual assessment. On the other hand, For dwellings that are located in municipalities where at least 3% of the children tested 6 years of age or younger have a blood lead level greater than or equal to 5 micrograms per deciliter, that inspection must be carried out through dust wipe sampling. Now, these inspections apply to the interior living spaces of those dwellings, and the department's website, in the link that I shared at the beginning of this chat log, has the information for what type of inspection each municipality is to undertake. And that's based on data that was received from the New Jersey Department of Health from their screening levels. So from there, of course, we have our inspection timeline. Once that periodic inspection occurs, what does that look like throughout the years as we move forward with this law? So again, for any non-exempt units, after your initial inspection is conducted, those units need to be inspected for lead-based paint hazards every 3 years or upon tenant turnover, whichever is earlier. The only time you won't have to do an inspection upon tenant turnover is if the owner has a valid lead-safe certification. Those lead-safe certifications are valid for a period of 2 years. So with that in mind, if the lead-safe certification has expired and there's a tenant turnover, an inspection is necessary before that 3-year inspection. So just keep that in mind. And of course, just to keep things moving along, an inspection upon tenant turnover should always be resetting your clock for your 3-year inspection. So the 3-year inspection is the standard with this tenant turnover where there's an expired lead-safe certification. I know that usually looks kind of confusing. It's a lot to take in. We have made this little timeline where I tried to provide hypothetical dates to help walk through this process, because you have a 2-year and a 3-year that you're kind of juggling between. But the way that this one shakes out is, say you have your initial inspection July 1st, 2024, and the property is lead safe, thankfully. So you can issue a lead safe certification. That's valid for 2 years. You're going to schedule your next inspection 3 years out in July 1st, 2027. But bearing in mind, of course, that that lead safe certification is going to expire on July 1st, 2026. So say from there, the tenant moves out on October 1st, 2026. Because that lead safe certification expired, an inspection upon tenant turnover is necessary. Thankfully, in my made-up scenario, the property is still lead safe. So a lead safe certification would be issued again, valid for another 2-year period. So that resets that 2-year period clock. That new certification is going to expire October 1st, 2028. Your next inspection was scheduled for 3 years out from October 1st, 2026. So it's scheduled for 2029 with the information in mind that if the tenant were to move in November of 2028, the dwelling would need to be inspected at that time. So now we're going to move into the types of inspection, and I want to break down what these inspections look like a little bit more and probably give you some peace of mind for who can be doing these inspections and how, because I know that that, of course, is going to be one of the biggest questions that municipalities have. So for visual inspections, any municipality that can perform visual assessments, the inspector should be looking at rental dwellings for deteriorated paint or visible surface dust, debris, and residue. One thing to note here is that in the guidance document that is a part of the website that was shared with you previously, there's a whole section on visual assessments, and it has a link to HUD's training for visual assessments. And that is what municipal inspectors who are going to be performing visual assessments should utilize. That training should be undertaken and completed. It's actually just right through HUD's website, and that is the proper training to perform any visual inspections. But just to go into a little bit more detail on what that looks like, as Kaya mentioned earlier, paint is deteriorated when it's peeling, chipping, chalking, or cracking. Tack and nail holes are really small hairline cracks. If there's just surface imperfections, you want to take a look at those, because if it's not deteriorated around it, they may not be considered deteriorated paint. You really want to look for any tack or nail holes that also have this really bad chipping or dust or residue surrounding it that is deteriorating the rest of the paint. They should also be looking for any deteriorated paint on really any painted building components inside the dwelling, including walls, windows, and trim. Also, of course, look at those impact surfaces that Kaya mentioned earlier. Any two surfaces that are sliding across each other, that paint can become more quickly deteriorated. So of course, doors, windows, your trim areas, they may have more deterioration. You want to have a careful eye to those areas. You should also be looking around just for any paint chips or dust from any painting activities that was not cleaned up, because that could be leaving residue on floors that is a continuing hazard. So that's how the visual assessments are undertaken, and the HUD training really does go into that in more detail. There's also dust wipe sampling. So for municipalities that have to undertake dust wipe sampling, there's an EPA and HUD course that they do for any dust wipe technicians, and that is the information that spells out exactly how dust wipes need to be undertaken. And towns that have to perform dust wipe sampling should really be looking in to assuring that they can get a dust wipe technician ready to perform these dust wipe samples, because it is very necessary to undertake these properly to ensure accurate results. So with dust wipe sampling, it really is pretty much what it sounds like. It's taken by wiping a representative surface, which includes like floors, whether they're carpeted or uncarpeted, and interior windowsills and other similar surfaces. And those are tested in accordance with methods approved by HUD. So when you're thinking of a representative surface, think anywhere that collects dust. The horizontal surfaces within the home are what should be tested. These samples do have to be undertaken properly, again, to ensure that results are accurate. The department regulations at NJAC 5:17 do contain requirements for dust wipe sampling, and Appendix 13.1 of HUD's guidelines for the evaluation and control of lead-based paint hazards also provide protocol for dust sample collection. So those are also really great resources. It's also, of course, recommended that where you're performing a dust wipe, look around, do a visual assessment as well, because chances are, if it's a pre-1978 dwelling and there's a bunch of deteriorated paint, you probably know those dust wipe samples have a high chance of being leaded. So this, of course, leads to a very important question that I'm sure is brewing in everyone's brain right now, and that's fees for inspection. So in accordance with this law, municipalities must charge the dwelling owner or landlord a fee sufficient to cover the cost of inspection. So for any municipalities that have to hire a lead evaluation contractor to perform that inspection, the fee should also include the cost of hiring that lead evaluation contractor. In addition to the fee that you set, there is also a requirement for municipalities to charge a $20 surcharge for every unit inspected. That surcharge fee must be deposited into the Lead Hazard Control Assistance Fund unless the department has already assessed this fee. The only time you'll see that the department has already assessed it is in the case of multiple dwellings, because that surcharge is already performed by the department. And I know we receive a lot of questions about depositing this money. I do want to let you know there is information forthcoming about ensuring that these surcharges go to the right place. And I also wanted to just put this cost into people's mind. This isn't a concrete number, but I understand that the cost of this work will vary greatly depending on the inspection performed, the areas that need to be sampled through dust wipes. And to provide some rough numbers, I did speak with our Division of Housing and Community Resources, which runs a lot of different lead programs and projects. And often, through some rough numbers, a dust wipe sampling can cost around $360. This, of course, will be based on labor, supplies, lab testing. So I know it may change from municipality to municipality, but I wanted to give at least an estimate number for those dust wipe towns to have a bit of a concrete idea in your mind of what this might pan out to look like. Of course, we went through our inspections, we went through the fees, so we have the results of the inspection. And of course, the easiest of the results is that there will be no lead-based paint hazards. And if that's determined, then the contractor performing the inspection or the local enforcing agency will certify the dwelling as lead safe. And that is done through the issuance of this lead safe certification. It's valid for a period of 2 years. In a case where it's being performed by a lead evaluation contractor, both the owner and the municipality must receive the inspection results. The documentation will vary, of course, based on the inspection performed. For a dust wipe sampling, you'd also receive the results of that dust wipe sampling. But for a visual inspection, you're always going to just be looking for this certificate. And for any inspections, this certification is the final piece of paper to show that there were no lead-based paint hazards. So this is something that's very important to have record of, to keep on file, so that you know the results of the inspections that have been performed. This form is available on the department's website, again at the link I shared in the beginning, and it's a fillable form. Now, on the other hand, of course, you may find lead-based paint hazards in the dwelling. So if lead-based paint hazards are found during an inspection, the owner of the dwelling unit must remediate the lead-based paint hazards. And they can do this either through lead-based paint hazard control methods, which are interim controls, or through abatement. It's also important to note here that if lead-based paint hazards are found during the course of a visual assessment, the owner of that dwelling may elect to order a dust wipe inspection just to confirm the presence of lead-based paint. If they feel that the chipped, deteriorated paint is not leaded, that can be a next step. So I just wanted to point out here that there are a few things to keep in mind if lead-based paint hazards are found, especially if there is a tenant in the apartment at the time of the inspection. There is actually a good resource for this. Our regulations at NJAC 5:17 again speak to whether an occupant can stay in their dwelling during any specific project, so that can come into play for tenant situations. Usually that determination, if remediation is ongoing, is made by the lead evaluation contractor in accordance with those regulations. So let's move into what remediation looks like. Remediation work must be performed by any certified individuals in accordance with all applicable federal and state regulations. Now, of course, I understand that it's going to be the owner undertaking this, but I think it's really important and helpful to understand what kind of work that owner will be doing, so you know what you should be looking for upon re-inspections. And as Kaya noted before, our department certifies the firms that perform lead evaluation and abatement. We have that list online. The New Jersey Department of Health also licenses the individual lead inspector, risk assessors, and abatement workers. They have further information on their website. The third leg to this is that the United States Environmental Protection Agency also certifies renovation, repair, and painting contractors. These firms are certified to perform renovation, repair, and painting work, just as it sounds, that address lead-based paint in homes and childcare facilities. So this work is often involved in interim controls. So if there are interim controls being undertaken in a structure and a contractor is responsible for it, that contractor has to have an RRP certification. That information is also available online. I do also want to say here, it's a bit of a divergence, but something to keep in mind, that if you performed this inspection and it's quite clear that there is a child in the dwelling, either you saw the child or there's toys everywhere, it's just clear, it is a good idea to notify the local health department that the child may have been exposed to lead-based paint. Now, of course, we won't always know exactly the level of paint, especially in a visual assessment, but reaching out just so all the local departments know, hey, there may be an exposed child in this home, is for the best. It's for the safety of the child. I wanted to move into what these two forms of remediation look like. Firstly, we have interim controls. And what interim controls are measures that are designed to temporarily reduce any human exposure to lead-based paint hazards. So interim controls are easiest and very appropriate to do when fixtures overall in the building are structurally sound, and really that main exposure is just deteriorated, aged paint or excessive levels of dust. Interim controls are also really appropriate if you're going to be undertaking some pretty extreme renovation or even demolition in the next few years, because it will be making the home more safe, and the more costly abatement is not always warranted in those issues. So interim controls include a lot of pretty easy to grasp concepts, things that you would be looking for in this. And examples of that include paint stabilization. So in paint stabilization, all deteriorated paint on interior surfaces should be stabilized in accordance with HUD guidelines. So think if you have any deteriorated paint in the home, that can even be as simple as repairing that deteriorated paint to make sure that it's not dusting and flaking and chipping into the environment and the atmosphere. There's also making surfaces smooth and cleanable. So think of surfaces like floors, stairs, even windowsills that are rough or porous in any way. Those should be made smooth and easy to clean. So I actually noticed pretty recently looking at one of my windowsills in my home. It has a lot of little porous areas. Anywhere dust can settle in an interim control, it's important to make that smooth and cleanable. That can often be corrected even just by spackling and recoating. Otherwise, they might have to cover it with a surface or a material like plastic or sheet vinyl, but it's just making sure you have one flat surface that doesn't collect dust. There's also just correcting dust generating conditions, and the HUD guidelines do give a lot of the different measures that are included therein. So if you know that an owner is performing an interim control, these are the kind of things to keep in mind for what they may have been doing. On the other hand, you have abatement. Now, abatement completely resolves any exposures to lead-based paint hazards for the residents of the dwelling. In certain cases, interim controls aren't really effective, especially if the building has a lot of structural defects or any of the major components are really deteriorated or even subject to excessive moisture, because that moisture is just going to continue bringing that lead back up to the surface. So in those situations, interim controls won't really be effective, and abatement will be more appropriate to address those hazards. The reason I reference abatement being the more extreme project is not only just because it does negate the hazard in a much larger way than an interim control does, it's also much more costly. So abatements can range from $13,000 to as high as $40,000, depending on the scope of the project. So that's why you have these two different options. We're not going straight to abatement in this law. Abatement measures include paint removal. Instead of just stabilization and abatement, you're fully removing that paint. So this includes removing the paint through mechanical methods. So that includes wet scraping, wet sanding, and any sort of non-abrasive blasting, just fully removing the paint from the structure. It also includes building component replacement. So this would be the careful removal of any building component which contains a lead-based paint hazard. Think if it's all on a door, it would be removing that door and fully replacing it. Bearing in mind, of course, that you cannot bring in the new component until you've removed the old component and it's been entirely cleaned, just to ensure that the new component isn't immediately exposed to lead-based paint hazards. Another method for abatement is enclosure, and this includes, just as it sounds, enclosing the lead-based paint behind other materials. So like drywall, fiberboard, or any equivalent are great for interior wall enclosures. In like a bathroom or anywhere that's moisture prone, you may need a moisture resistant green board in damp areas. And this is just to ensure that the material you're using cannot have the lead-based paint seep right back through to the surface, because of course that would negate the purpose of the enclosure. Similarly, if it's flooring that needs to be addressed, it does have to be covered with a 1/2 inch or thicker of plywood before anything else can be placed on top. And that's just, again, so the lead can't just absorb and seep back through the new component. So with all that in mind, the owner has undertaken their remediation effort in whichever way that they've chosen. And this comes back to a post-remediation inspection. So after the remediation has been completed, regardless of whether it's through interim controls or abatement, the municipality or the lead evaluation contractor must perform an additional inspection within 60 days of that initial periodic inspection, just to ensure that there are no further lead-based paint hazards. So if you're conducting this inspection in a dwelling that was remediated using interim controls, if no lead-based paint hazards are found, the municipality or the inspector will certify the dwelling as lead safe with that lead safe certification. Because interim controls are only intended to temporarily reduce exposure, you would get a lead safe certification, because there could be, lead-based paint could re-enter the environment and an exposure could happen later. So for that reason, interim controls will lead to a lead safe certification pursuant to this law. Now, if the dwelling was remediated using abatement, all abatements have to follow NJC 5:17, and a lead abatement clearance certification would be issued by the local enforcing agency. Clearance would have been performed by a lead evaluation contractor. So when there's been remediation through abatement, a lead-free certification is what's issued at the end of that. So the reinspection for an abatement, the inspector should be looking for the lead-free certification and the final clearance. So any abatement that results as a result of this act would lead to a lead-free certification. And as Kaya noted back in the beginning, that would make them exempt from future inspections pursuant to this law. Now, I am going to be going back to Kaya here for some best practices, some things to really keep in mind. So with that, thank you all for listening to my very in-depth portion, and I will go back to Kaya.
Thanks so much, Marie. So a couple more areas that are important to note as we discuss the act. So it's important to really go over the requirement under the act for record keeping. So municipalities are required to keep track of all rental dwellings that are subject to the requirements under this act, their inspection schedule, and whether a lead-based paint hazard has been found. In addition to that inspection schedule, municipalities must maintain a copy of any lead-safe certifications in their records for the property. So it's important to note, right, that municipalities do have this obligation for record keeping. It will be critical to work amongst your respective offices, right, to ensure that these documents are kept in an area that are easily accessible should those documents need to be produced. I recognize every town is a little bit different, right? We have hundreds of municipalities. They operate under different structures and paradigms. So I encourage any municipal officials who are here to really think dynamically and thoughtfully with your colleagues and how best to address record keeping in a way that's accessible and organized. Another critical requirement under the act that we wanted to flag is the investigations component, right? So the act does allow and require municipalities to conduct investigations and issue penalties to enforce a property owner's failure to comply with the requirements of the act. I know we have seen some questions about, you know, how do you really compel an owner? But again, it's important to note that the act does allow for there to be penalty types of enforcement to compel action by dwelling owners when there are lead-based paint hazard concerns. If a municipality does determine that a property owner has failed to comply with the requirements of the law, that property owner is to be given 30 days to cure the violation, either by ordering the appropriate inspection or by initiating remediation. If that dwelling owner has not cured that violation within the 30 days thereafter, that owner is to be subject to a penalty not to exceed $1,000 per week until that inspection has been conducted or the remediation efforts have been initiated. And when we say initiation of remediation efforts, that means that the owner has either hired a lead abatement contractor or other qualified party to perform that lead hazard control method. As important as the obligation for investigations by the municipality, it's important to note that the department does have investigation authority. So when a complaint has been filed with DCA or of the commissioner's own accord, the commissioner is authorized to conduct investigations and issue penalties against a municipality for its failure to comply with this act. The department will be giving the municipality a period of 30 days to undertake those inspections or provide proof in the form of any valid lead-safe certs or notification that the lead-based paint hazards exist in that dwelling and remediation has begun. If a municipality hasn't cured that violation within 30 days, it shall be subject to a penalty not to exceed $1,000 per week. So again, wanting to flag these considerations so that everyone understands the various requirements of the act. Marie has just flagged here our resources page. So we wanted to make sure that was available. You can email us at this lead law email address. This information is also found in our guidance document and on the website. And then also here are some links to the HUD guidelines, EPA information, as well as Department of Health. I do want to leave room for my colleagues at DOH, Dr. Pappas and Morgan Patrick. Any additional comments or considerations that you wanted to note in the webinar today?
I think you handled it. Thank you very much.
Appreciate it, everybody, and thank you so much.